When someone is arrested at the scene of a crime or an alleged crime and they're taken into custody by the police right away without a search warrant, which happens quite a bit, then people want to know, well, what's going to happen next? So some examples of that where that could happen is a DWI situation or an assault situation, really anywhere where the police haven't already planned something out and gone and got a search warrant. So think of it as an arrest right after an alleged crime. And in that situation, if police do not release them right at the scene or release them right away at the jail, what will happen is that people are going to be held until they can be brought before a judge. And we have rules of criminal procedure in Minnesota that have to be followed. And one of those rules is that if someone is arrested without a warrant, then they have to be brought before a judge within 36 hours, not including the day of arrest, legal holidays, or Sundays. So, for example, if they're arrested on Tuesday at 4 p.m., Tuesday doesn't count towards that 36 hours because that's the day of arrest. So you got Wednesday, they've got the whole day Wednesday, 24 hours, and into that Thursday at noon. That's the 36-hour period that they have to be brought before a judge. And the rules also say without unreasonable delay, so that should happen before those 36 hours, but sometimes it doesn't. Now, if they're brought in usually on a felony charge, then they have a right to up it to 48 hours where a complaint can be filed by the prosecutor within the 48 hours, and a judge has to find probable cause within that 48 hours, or a prosecutor can swear to probable cause within that 48 hours in that complaint that has to be filed. And so that's for more serious charges. But that 48-hour rule is a little more confusing because not only do legal holidays, the day of arrest, and Sundays not count, but also Saturdays don't count on the felony charges. So you could be brought in on a Thursday and not get before a judge until a Monday potentially under that rule, as an example of how it could work. Now again, I'm talking about only in cases where police do not have an arrest warrant, or they haven't planned out an arrest in advance. So in those situations, what happens is the person's arrested, they're brought down to jail, and they've been charged by the police with the crime or by a prosecutor forthcoming with the crime. And what we as defense lawyers will do is contact a judge if we're hired to represent someone that's under investigation and that hasn't been before a judge yet, and we will ask the judge to release them without bail before even being brought to court, so we can save people from being fired from their jobs for missing work and things like that. Sometimes that works. Other times it requires us to ask a judge, if the judge won't release them, to have a judge set bail without even having to appear in court. Again, to speed up this process, a judge can set bail. You can then bond out or bail out, and then you can get back to work without sitting there for the whole weekend or missing work for a day and things like that. And a lot of times that works, but sometimes that doesn't work. In that situation, we'll try to get him kicked out if those 36 or 48-hour rules are not observed by the jail or by the court or by the prosecutors. And then finally, in some situations, you're just brought before a judge because they've been able to get to you before your 36 hours is up, or your family member, or they're not willing to release someone without having what's called a bail hearing, which is an initial appearance under Rule 5 of the Minnesota Rules of Criminal Procedure. Again, so I'm talking about people who are arrested without a warrant. I'll make a separate video if we're talking about people arrested on warrant. But if you get before a judge and you're not released early, and now you're before a judge for a bail hearing, what's required is that, number one, in an initial appearance, the court is required to tell you what crimes you are accused of or charged with. Another thing a court has to do is tell the person what their constitutional rights are: their right to remain silent, the right to have a lawyer present, their right to be presumed innocent, and those sorts of constitutional rights. And then a court has to deal with, if they want to take a plea of guilty from someone right off the bat, that you always have a right to plead guilty right away. We, as a matter of practice from a defense standpoint, rarely, if ever, would have a client enter a guilty plea at an initial appearance, and that is because the evidence hasn't even been processed yet and furnished to us, so we can't take a look at it to see if there are any legal defenses or be in a good position even to initiate any plea discussions if the case has to go that route. And then finally, among those things that a court has to do, a court has to then decide whether to order bail to be set order the person just released without any bail or any conditions whatsoever and just give them a new court date, or to do something in the middle, which is to order them released but with conditions of some sort. When a judge decides whether to order bail or not, they look at a number of factors, and some of them are things like what is the severity of the alleged crime that the person's accused of? How strong is the evidence against the accused person? Does the person have a prior criminal record? Does the person have a prior history of not showing up to other court appearances or having other warrants out for their arrest in the past or currently? Or on the other side of that, have they shown, if they have been to court before for things, have they shown that they always appear for court when they're told to be, because then they're not so much of a flight risk? What kind of ties to the community does a person have? Do they have a job in the community? Do they have family in the community? Have they lived in the community a long time? When a judge decides to set bail, that's supposed to be the worst thing that a judge can do. And the rules say, judges, you're supposed to look at least restrictive options instead of jail, or instead of bail. Things like conditional release or letting somebody go with giving them another court date and a promise to reappear. So bail is supposed to be for, in the case that the judge has a concern that the person is a flight risk and will not appear for any future court dates, or that they are a danger to the public. But historically, bail is really supposed to be for people who are a flight risk. All right, then if we're dealing with conditions, if a judge does not set bail or wants to do one high bail, let's say $100,000, and then, but with conditions, if you follow these conditions, you can do conditional bail for $10,000. And they might say things like, your conditions, let's say it's an alcohol-related offense like a DWI, or it's an assault with drinking, or it's a drug case. They might say no alcohol use or possession, or no drug use or possession, and they might do random testing or an alcohol bracelet to make sure that while the person is released on conditions, that they're really following through with these conditions. And if you foul up and you break those conditions, a judge can order you taken back into custody. Another thing they could do is no contact with an alleged victim, and that really gets dicey, especially in domestic assault cases where husband and wife are together, they've lived together in their home for the past 15 years, they have kids together, and all of a sudden the alleged abuser or alleged assaultive person can no longer have contact with their spouse and cannot even be allowed back in their own home, even if it's their own home. So those are other conditions that a judge can place on release. Or they have a right to just release you on your own recognizance, which means you promise to reappear, they give you another court date, and then you come back at another date to continue on with the court process. So when somebody is arrested without a warrant, that's typically what you can expect for the first court appearance, or in order to try to get out prior to that. I'll make additional videos where we're dealing with somebody that's been arrested on a warrant. So if that's the situation, look for that video. If you have questions, my name is Ryan Pacyga. You can find me at www.arrestedminnesota.com or follow me on Twitter at ArrestedMN.